Does the requirement that an electronic logging device be installed in a commercial vehicle violate New York's constitutional protection against unreasonable search and seizure? To find out, you have to read OOIDA versus New York State Department of Transportation, but it's 19 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Owner-Operator Independent Drivers Association versus New York State Department of Transportation, published by the New York Court of Appeals on June 13th of 2023. The citation for this case is 2023 New York Slip Opinion 03184. I'll include a link to that decision in the description. The issue in this case is, does the requirement of having an electronic logging device in a commercial vehicle violate New York State's constitutional protection against unreasonable searches and seizures? I'll explain all that in a second. Some background to understand and appreciate what's going on in this case is that New York State, the same way the federal government has the Fourth Amendment, which I think a lot of us are familiar with, which protects people from unreasonable search and seizure absent a warrant, New York State has that too. It's Article 1, Section 12. And in some substance, it's the same thing as the federal rule. The other thing you have to know is that in 1930s, as far back as the 1930s, maybe 1937, there have been hour maximums for commercial drivers, because we all understand through experience that driving can be a dangerous activity, and fatigued driving is even more dangerous, especially if a driver is driving a multi-ton vehicle, commercial vehicle, a tractor trailer, something like that. So as far back, for about 80 years now, we have experience with maximum hour limits and requirements. And what that means is over the course of those 80 years, mostly what commercial drivers have had to do is they carry little pads and they write down on duty this hour, off duty this hour, mileage, name and what where they've gone and where they're going. But in 2012, what happened is that Congress passed a law. They basically started requiring regulations that would put ELDs, electronic logging devices, into all commercial vehicles that would monitor automatically. They would be logged and connected to the engine, would log when the engine goes on, when the engine goes off. It would also have GPS capability and say where in the world you were within an approximate radius of 10 miles or so. And in addition, it would require these regulations that Congress sought in 2012 that upon request, law enforcement could ask for that information, the logging details, the mileage, the location, and be given that material. Now, this has been required by the Federal Motor Carrier Safety Administration, the FMCSA, by many states. Their job is to make these rules and then talk to the individual states about how they're going to comply with these rules. New York State's late to the party. We're the 48th state to adopt these rules. And basically, the rules were supposed to be effective April 24th of 2019, the 48th state to do so. And the agency responsible in New York State to ensure that it's being complied with is New York State's Department of Transportation. When they tried to impose this rule that commercial drivers had to have this electronic logging device attached to their vehicles, connected to their engines, so that the officers could wirelessly transfer and retrieve this digital information if they needed to, if they wanted to check and make sure everyone's complying with these requirements. The plaintiffs in this case, the Owner-Operator Independent Drivers Association, went to court, and they went to court a lot. This is the third case. First, they went to federal court and said this violates the Fourth Amendment. Federal court said, no, it does not, because it's a pervasively regulated industry. That's an exception to the warrant requirement. So then they go to New York State court and they file a class action lawsuit. New York State court says, nope, it's a pervasively regulated industry. So they deny that. Then finally, and what the instant case is they file an Article 78 proceeding. An Article 78 proceeding basically is a proceeding saying that an administrative agency is acting beyond the scope of their authority. And they claim that the New York State Department of Transportation is acting beyond the scope of its authority because it's violating New York State's Constitution, Article 1, Section 12. And that's what we have here. The appellate division, trial court denies grants the motion to dismiss. The appellate division affirms it, and now we go to the Court of Appeals. And they say that when you make a facial challenge to a regulation, this is sort of as a general basic rule and understanding here. when a plaintiff makes a basic facial challenge to regulation, they have an extraordinary burden, that's what they say, of proving beyond a reasonable doubt. This is the strongest language I've ever heard in terms of a challenge, what the standard is. Beyond a reasonable doubt that the challenge provision suffers wholesale constitutional impairment. The challenger must establish that there is no set of circumstances under which the act would be valid. And there's a case called Quackenbush that says that administrative searches can be upheld, that it's an exception to the warrant, to the Article 1, Section 12 prohibition against searches and seizures if, number one, the activity or premises is subject to a long tradition of pervasive government regulation, and number two, the regulatory scheme must delineate rules to guarantee the certainty and regularity of the application of those rules. So, which basically would provide a substitute for that constitutional substitute for the warrant. And also, the last thing is you have to check to make sure it's not just a pretext for criminality, for checking, for basically piercing someone's privacy to check and see if they're committing a crime. Now, then the court goes through analyzing the ELDs and says, first, that's the first element, there's a more than 80-year history of this being a pervasively regulated industry. There's a long history of regulation of max hours. So number one is satisfied. And it's not pretextual. This is a real thing. There's real factual findings here that it's dangerous to drive if you exceed the number of maximum hours. As to the second element, whether it's a limited search, they talk about how the ELDs are by their very nature, they're limited. It records locomotion, it records location, movement of vehicle, and the duty status automatically. It's obtained without the officers ever entering the cab or the vehicle. It does not authorize entry of the cab or the vehicle at all. And lastly, they say it can only be obtained if the vehicle is already stopped. So there's not a basis to pull a car over to check it. The car already would have to have been stopped and seized for other reasons that can be challenged in court. And for those reasons, and lastly, they say this is not pretextual. And for that reason, they say this is a constitutional rule. The New York State Department of Transportation is correct in applying it. And they say the goal is administrative inspection. It's not criminal. And therefore, they affirm the trial court, they affirm the appellate division, and that's the case of the Owner-Operator Independent Drivers Association versus New York State Department of Transportation. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.